Man's capacity for justice makes democracy possible, but man's inclination to injustice makes democracy indispensable. Hello everyone and welcome to BYJU'S Exam Prep IAS and welcome to a video on the landmark judgment, the turning point, the milestone, the watershed in the field of constitutional judicial review, the Kesavananda Bharati Judgement of 1973. Today marks 50 years of the judgment. The judgment was passed on the 24th of April 1973. A 13-judge bench, 7:6, a wafer-thin majority, upheld the validity of 24th Amendment Act 1971 and gave to us the Basic Structure Doctrine. And of course, it has been the longest running case as far as discussions are concerned, with 68 days of discussions going on, barring of course the holidays in between. So let's begin our discussion on what this case was all about. First up, this issue of basic structure comes up with our constitutional provisions into picture. So what had happened was, we had in 1940s, the late 1940s, the government trying to go for some land reforms, meaning take land from rich people, give to the poor people, make tenants the owners of the land. So let's say there is a landlord who has a large tract of land. Now, all those tenants who were working on this land for say around 50, 100 years or generations, tenants, it was said that now you would become the land owners, meaning you were actually going to take land from the rich zamindar and give it to the tenants. This meant violating a fundamental right present in the Constitution. That was Article 19, Clause 1, Subclause F, the right given to every citizen to acquire, to hold, and to dispose of the property. So of course, that became the cause of concern for the government and the zamindars. Why? Why? Because of a conflict. A conflict in our Constitution between Article 13, Clause 2 and Article 368, Clause 1. So what exactly is Article 13? See, Article 13 talks about laws being inconsistent with or in derogation of the fundamental rights. So Clause 2 says that the state which is defined under Article 12, the state shall not make any law. So a law will not be made by the state which takes away or abridges. Abridge means to reduce, to make short, curtail. So the state shall not make any law which takes away or abridges the rights conferred by this part. Which part? We are referring to Part 3 of the Indian Constitution, the fundamental rights. And any law made in contravention. Contravention means violation, some infringement, breach. So any law made in contravention of this clause, that is 13 Clause 2, shall to the extent of that contravention be null, be void, no legal force. So let's say there is a law with say 100 provisions. If 5 provisions of that law violate the fundamental rights, then those 5 provisions will be cancelled, the law remains. So you cannot make a law which violates the fundamental rights conferred to us by this Constitution. And law has been defined in the very Article 13, the next clause. Law would include things like ordinances, orders, bylaws, rules, regulations, notifications, even customs in our country. So no such thing could exist while it violated the fundamental rights in the country. Now, what's the conflict? We have one more article, 368. Of course, we know the article which allows us to amend the Constitution. with her special majority. So what does this article say? Notwithstanding anything in this constitution. So notwithstanding refers to in spite of. In spite of anything mentioned in the entire constitution, Parliament may, in exercise of its constituent power, amend. So Parliament can amend by way of addition, by way of, say, variation, subtracting things, or repeal, remove completely any provision of this constitution. Mind you, any provision of this constitution, in spite of whatever is mentioned in the constitution, the Parliament can modify or rather amend any provision of this constitution, which may also mean part 3, of course, in accordance with the procedure laid down in this article. So the procedure basically is a special majority which is required, which is what? 2/3 of present and voting, more than 50% of the total strength or membership, whichever is more. Now, this is where the conflict is, because you cannot make a law to take away fundamental rights, but you can amend everything. So, this was the idea used by the government. So, the Parliament, what it did was, it modified the constitution by passing the first Amendment Act in 1951. And with this Amendment Act, it also inserted a couple of other articles like 31A and 31B. A Schedule 9 was added, and Parliament was given the power to amend the fundamental rights. And the Parliament said, this is amendment, it's not a law, because the definition of law does not include amendment. Of course, it was challenged immediately in the Supreme Court. So the challenge came in the Shankari Prasad case 1951. Now, of course, this idea being put interestingly that amendment is not a law, because had amendment been a law, it would have been covered under the definition of Article 13, which it was not. That is why in the Shankari Prasad case, in fact, for a large part of our early days, right till this phase, the Supreme Court held that fundamental rights are amendable. Meaning what? Meaning that the Parliament could take away our fundamental rights using Article 368 by modifying the Constitution. Now, all these zamindars, think of this, the government has a list of sorts with all the names of all the zamindars, and their land is being taken away one by one and being given to the poor. The government playing Robin Hood. Zamindars would approach the court. The court's adamant on this particular idea that amendment is not a law under Article 13, and hence anything and everything can be amended. But for the first time, in the Sajjan Singh case, Sajjan Singh versus State of Rajasthan, a 5-judge bench. Now, in this case, the judgment remained the same. The petition was dismissed of the zamindars. But one judge in the bench, Justice Raghunath Mudholkar, he came up with a very unique concept. He just asked a question that can the Parliament have this unfettered, unlimited, unrestricted power to modify everything? This was the first time that somebody had tried to raise this issue that there should be a limitation of power of the Parliament. I mean, people may also claim that Justice Mudholkar was trying to also quote or make a reference to a case in our neighboring country, our best friends Pakistan, Fazlul Qadir Chaudhary case of 1963, where the Pakistani court said the same thing. Or maybe in the Berubari Union presidential reference of 1960, a similar kind of concept was thrown at us by the Supreme Court, stating the limitation on the Parliament's power to make changes. And there, in that Berubari Union, the Supreme Court had said that Article 3 cannot be used to give up land to other countries. Article 3 is meant only for domestic reorganization. So yes, indirectly in the Berubari Union or directly in the Sajjan Singh case, this concept did come up for discussion. Anyway, nothing much could be done about it. Finally, in 1967, 11-judge bench sitting together with a judgment of 6:5. Suddenly, Supreme Court had a change of heart. It said, no, fundamental rights cannot be amended. You cannot take away fundamental rights. Because here Supreme Court tried to use a larger definition of law. Because amendment, after all, is also a law. Just because it is not mentioned under Article 13 does not make it cease to be a law. It is just like law. So a broader definition was seen, and we saw that amendments will not be allowed for fundamental rights. And it was Justice Vanchu who actually echoed the sentiment, who became the Chief Justice later on, this very same year. And this is where the government, right, received a jolt on their way to land reforms across the country. It was a major check on the government's power. Now, interestingly, this Golaknath case was actually a case from Punjab. So there was a family of two brothers, Henry and William Golaknath, who held over 500 acres of land between them in Jalandhar, Punjab. And in 1953, a law was passed called the Punjab Security and Land Tenures Act, under, of course, the First Amendment Act, placed under Schedule 9. So we also know that there is something called Schedule 9 of the Indian Constitution, wherein if you place any law, it is immune from judicial review, at least till 1973. Now, according to this particular law, the brothers who held 500 acres of land, their property was being taken away, and the government said that you keep 30 acres each, full enjoyment of 30 acres each. Give the rest to us. So taking away almost 88% of land and letting them keep 12% of land, 60 acres in total. Of course, this matter had gone to court when the brothers challenged it on the grounds of violating Article 14, Article 19, Clause 1, Subclause F, Subclause G. Subclause G refers to practicing any profession, occupation, trade or business, meaning every citizen has a right to practice any profession, any occupation, any trade or business. Now, this judgment is very unique, the Golaknath case, because in every judgment, courts function in an adversarial format. A versus B, A wins, B loses. Now here, when the court said rights can't be amended, it placed a limitation on the parliament. The government is unhappy. But do you think Golaknath family was happy? Of course not. The Supreme Court said, see, what has happened so far. If your land is gone, it's gone. From this date onwards, we will not modify or amend the fundamental rights. So interestingly, both parties were unhappy and went crying back home. But, and just to point this out, in fact, Supreme Court has had very high regard for fundamental rights. In the A.K. Gopalan case, Supreme Court has called these fundamental rights as paramount. In the Champakam Durai Ranjan case, 1951, it has called these rights as sacrosanct. Sacrosanct, something which is too important to be interfered with. In the M.S.M. Sharma case, 1959, Supreme Court has said that these rights are reserved by the people. In the Ujjambai case, 1963, Supreme Court called these rights as inalienable, not subject to be taken away, inviolable. Of course, in the Kesavananda Bharati, referring these rights to the ark of the Constitution, something that provides protection to the people of this country, to democracy of this country. So this judgment was actually in line with what Supreme Court had been saying over the years in various cases. But of course, this judgment came when Indira Gandhi was the Prime Minister, and she said, "Don't mess with me." And the whole confusion was around this word amendment and this word law. Back to the same old story of this confusion. Now, Indira Gandhi said, this is the confusion, right? Article 13 becomes applicable on Article 368 and places a limitation that you can't amend the fundamental rights. Very simple. The solution to counter Golaknath judgment came through the 24th Amendment Act of 1971, where two changes were made. Change number one clause was added to Article 368. 368 clause 3. And it simply said, nothing in Article 13, which places limitation, shall apply to any amendments. In short, through this change, the government said amendment is not a law and amendments are allowed. Parliament can amend everything. It also made a change. Article 13 clause 4 was inserted that nothing in this article, which article? Article 13, shall apply to any amendment of this constitution made under Article 368. Basically, Article 13 is not applicable on Article 368, meaning no limitation on Article 368. Notwithstanding anything, the Parliament can add, vary or repeal any provision of this constitution. So this is where the story should have ended, but of course it did not. The story continues. And herein comes to light the Kesavananda Bharati case. In fact, in 1967, in the Golaknath case, Supreme Court had such a drastic change of heart from the previous judgments that it said that fundamental rights are given a transcendental position in the Constitution. It also went ahead to make a statement that if you want to amend fundamental rights, you would have to create a separate constituent assembly for it. Such was the respect, the extraordinary placement of the rights, the provision of our Constitution Part 3 that Supreme Court relied on, the superiority and the respect being awarded to the fundamental rights. Anyway, so coming to our case into picture now, the Kesavananda Bharati Judgement of 1973. So what is this case all about? See, Kesavananda Bharati, who passed away a couple of years back, he was the seer, the chief priest, the pontiff of Ednir Mutt in Kasaragod district in Kerala. He was challenging a law which was again passed under the provisions of the 9th schedule, the First Amendment Act, which was the Kerala Land Reforms Amendment Act 1969, which placed restriction of management or restriction on the management of religious property. And Kesavananda Bharati claimed that this was the only source of income for the temple. If you take away our religious land, you are also violating Article 26. Article 26 is the freedom of religion. So Article 26 is more of a group right compared to Article 25, and Clause C and D allow religious denominations to manage their property. This meant that if you take away their property, it violates the fundamental right. And that is why the question was raised in the Supreme Court in 1970 that this is wrong. In the meanwhile, 1971 amendment had come into picture. So now the matter in Supreme Court was not just this, but also checking the validity of this, whether the Parliament can give to itself this kind of extreme power to amend everything or not. after 68 long days of discussions. The second longest discussed case in Supreme Court is the Ayodhya case of 42 days. Third one being the Aadhaar case, 38 days. And with 13 judges and the judgment coming with a wafer-thin majority, 7-6, on the 24th of April 1973, Supreme Court actually upheld the constitutional validity of the 24th Amendment Act. In fact, it accepted it. Yes, amendment is not a law. Fundamental rights can be amended. In fact, everything can be amended. Government, very happy. As they were leaving the court judges said, wait, don't run away. Listen to me first. The court said, see, yes, everything is amendable except, the arc of the Constitution. Arc? The essence of the Constitution. The value system. The cornerstones. Judges, the lawyer said, my lords, please explain. What is this arc? What is this value system? The court said, let's see. There are some parts of our Constitution which are very essential to the Constitution. Those parts are very, very basic. The most basic features of our Constitution. They can never be amended. The lawyer said, sir, my lords, can you please define what is basic structure? The court said, definition, sorry, we can't define it, but we let you know in future, as and when the time comes, what all things are a part of basic structure. For example, supremacies of the Constitution is a basic structure. India being a sovereign, a democratic, a republic is basic structure. You can't modify it. The secular character of the Constitution, the separation of powers, the unity, the integrity, the federal character. These are some examples of basic structure. You can't modify these things. And that's how we came up with this very unique concept of basic structure doctrine, that there is some basic feature, or there are some basic features which can never be amended. Otherwise, you are free to amend each and every provision, including fundamental rights. No problem, right? And of course, Supreme Court has said that this concept of basic structure will be applicable only after the 1973 judgment. So any amendment you make from now onwards will be tested on the parameters of basic structure. So we call that the width test. Not really important, but width test. This basically refers to examining the boundaries of the amending power given to the parliament. What is the extent? And then we have the identity test. This means whether the amendment can actually alter, change the identity of the Constitution or not. We will not let you change the identity. We will also place a limitation on the boundaries of the amending power, upholding thereby a sort of rule of law, constitutionalism, and keeping very sacred something called judicial review. And over the course of various judgments, Supreme Court has come up with what are the possible elements of basic structure. So they have not defined it, but they have said that judicial review, rule of law, all these are various elements of basic structure, right? So that is all as far as this concept is concerned. Now, what exactly has been the advantage, the benefit? See, of course, this BSD, or the Basic Structure Doctrine, it acts as a check on this legislative eagerness. So sometimes you may feel that the legislature is very eager to make changes. So it places a check. And of course, let's always be sure, Parliament has no power to redraft the entire Constitution. You can, of course, make changes. As Ambedkar has said, that I am giving to the people a workable Constitution. You have to make it ideal. So while in pursuit of making this an ideal Constitution, we should not be given this right to redraft everything. It also has, preserved a sense of constitutional identity which is there for the constitution in the country. And of course, upholding rule of law, protecting against the arbitrary action of state. And frankly, judiciary has used it very judiciously. Very rare use. I mean, since 1973, there have been around 75 constitutional amendments. And maybe around 15 to 16 times the basic structure doctrine has been tested. Or rather, those amendments have been put on this very strong test of basic structure. In fact, 9 times it has always been held to be correct. No cancellation. Most of these are based on reservation policies. One such amendment was cancelled completely, and that was the NJAC, the concept of National Judicial Appointments Commission. This came through the 99th Amendment Act of 2014. This was the only amendment which has been cancelled comprehensively because it violated the independence of judiciary. Apart from it, various amendments, small parts of those have been cancelled. For example, in the 39th Amendment Act, which was some parts being cancelled because of the Raj Narayan case, wherein the Parliament had said that election of the Prime Minister, the President, the VP, the Lok Sabha Speaker, it is beyond judicial scrutiny. That was cancelled. Or the 42nd Amendment Act, 1976, which actually added 2 clauses to Article 368, Clause 4, Clause 5, stating that the amendments cannot be questioned or no limit on the Parliament's power to amend. So these were cancelled in the Minerva Mills case. Primarily, every such amendment which has been cancelled by the Supreme Court, or a small part of it which has been cancelled by Supreme Court, has always been on the concept of judicial review. So whenever you take away judicial review, Supreme Court is not happy. For example, the Quixote-Holohan case. The Quixote-Holohan case was with respect to the 52nd Amendment Act of 1985. That was the 10th schedule, wherein the Speaker's decision was final and beyond questioning. Of course, that part has been cancelled, thankfully so. Or even in 1997, the L. Chandrakumar case, wherein the High Courts were not given the power of judicial review of decisions of tribunals, which was also deemed to be wrong and improper. So largely these powers have not been misused, frankly. Of course, you can also say that there has been some international precedent to the judicial doctrine. For example, in the Bangladesh Supreme Court, Anwar Hussain Chaudhary case, 1989, the Bangladesh Supreme Court actually quoted Kesavananda Bharati. Or a couple of years back, in a court in Uganda, the same Kesavananda Bharati judgment was quoted. So this has been there as a presence internationally as well. But then, what are the challenges? See, first up, understand, there is no constitutional basis for this basic structure doctrine. So when the Supreme Court says that Parliament, you can't redraft the constitution, we'll have to remind the Supreme Court that, my lords, you also can only interpret, not rewrite the constitution. That's there. Also, a lot depends on subjectivity of the judge. There is no set definition. It is not defined at all. We just have examples, elements. It's not defined. It creates arbitrariness. People also say that, in a democracy, it's majority rule. It creates an illegitimate interference on the majority rule. And it is sort of preventing any kind of modification. And of course, such a wafer-thin majority, 7:6, had one judge changed his or her opinion, the matter would be different. So, of course, such a wafer-thin majority does not really inspire confidence in the judgment. And see, the elusive contours of basic structure doctrine stumps academicians, lawyers, and judges alike. And the applicability, the content, and the scope needs to be very clearly defined in completely unambiguous terms. No complication. The contours need to be defined to take away the subjectivity of the judge. In fact, this concept has yielded a couple of questions also in our UPSC examination. For example, a question asked in prelims 2020. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights, and democracy. Two things wrong. Firstly, basic structure is not mentioned in the Constitution. Secondly, there is no definition. One is wrong. Remove these two. The Constitution of India provides for something called judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. See, as far as this statement is concerned, it is slightly vague because frankly, provides for can have multiple meanings to it. But if you look in the Constitution, there is no specific mention of judicial review anywhere. In fact, any law which violates fundamental rights or the Constitution will be deemed to be void on its own. It's automatic. We need not ask the judiciary to cancel it. So a specific mention of judicial review is not there in the Constitution. It has come only through the Minerva Mills case 1980 when Supreme Court said that judicial review is also a part of basic structure. So keeping in line the understanding of whether it is actually given or not, of course not. So 2 is wrong and hence the right answer being D, neither 1 nor 2. There is a mains question as well, asked in 2019. Parliament's power to amend the Constitution is a limited power and it cannot be enlarged into absolute power. In the light of the statement, explain whether Parliament under Article 368 can destroy the basic structure of the Constitution by expanding its amending power. So it's as simple as that. Explain the line in the introduction. In the body, 2 paragraphs, the challenges of basic structure. You can write the advantages and then your conclusion with some suggestions on how to define the basic structure. That should suffice. So that's all as far as our video on Kesavananda Bharati is concerned, and with this we'll come to an end of our discussion for the day. That's all for me for this video, guys. Jai Hind.